come to order. Will the clerk please call the roll?
Senators Bridges, Buckner, Coleman, Cook, Coram, Danielson,
Excused.
Fenberg, Fields, Gardner, Janal, Gonzalez, Hanson, Heisey, Holbert, Jaquez Lewis, Kirkmeyer, Kolker, Lee, Liston, Lundin, Moreno, Pedersen, Priola, call him again? Or? Oh, here.
Absent.
Priola. Priola. Rankin. Rodriguez. Scott. Simpson. Smallwood. Sonnenberg. Story. Story. Story.
Here.
Winter. Woodward. Zenzinger. Call her again, she's there. Call her again. Zenzinger. Mr. President Garcia. Madam President.
Here. With 34 present, 0 absent, and 1 excused, we have a quorum. Senator Kirkmeyer, the good senator from Brighton, please lead us in the pledge.
Thank you. Would everyone please stand? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Approval of the journal, Senator Gonzalez.
Thank you, Madam President. I move that the reading of the Journal of Monday, February the 14th, 2022 be dispensed with and that the journal be approved as corrected by the Secretary.
You have heard the motion. All those in favor say aye. Those opposed say no. The ayes have it and that motion is adopted. Senate Services.
Correctly printed, Senate Bill 132, 133, 134. Correctly engrossed, Senate Bill 26, 27, 52, and 58. Correctly re-engrossed, Senate Bill 003, 14, 19, 45, 56, and 64.
Committee reports.
February 14, 2022, Committee on Health and Human Services. After consideration on the merits, the committee recommends the following. Senate Bill 79 be amended as follows, and as so amended be referred to the Committee of the Whole with favorable recommendation. February 14, 2022, Committee on Health and Human Services. After consideration on the merits, the committee recommends the following. Senate Bill 102 be referred to the Committee of the Whole with favorable recommendation and with a recommendation that it be placed on the consent calendar.
Third reading of bills. Third reading of bills, consent calendar. Will the clerk please read the titles to the 2 bills on the consent calendar?
Senate Bill 27, Senators Smallwood and Rodriguez, Representative Michelson, Janay, and Larson, concerning changes to the prescription drug monitoring program pursuant to the March 2021 audit report issued by the Office of State Auditor. Senate Bill 26, Senators Janal and Kirkmeyer, Representative Bazenaker and Rich, concerning an oil and gas operator's sole ability to review and protest property tax.
Majority Leader Fenberg.
Thank you, Madam President. I move the passage of all the bills
On the third reading of bills, consent calendar, which includes Senate Bills 27 and 26.
Is there any discussion on any of the bills? Seeing none, the motion is the passage of all the bills on the third reading of bills, final passage consent calendar. Are there any no votes on any of the bills on the consent calendar? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, Senate Bill 27 is passed. Co-sponsors on Senate Bill 27. Senators Moreno, Janal, Lee, Liston, Woodward, Buckner, Winter, Fields, Simpson, Gardner, Lundeen, Cook, Scott, colleagues, we're faster than the computer. If your arm's tired, put it down and re-raise it. Colleagues, we're going to have to redo those co-sponsors, so I'm going to call again. For co-sponsors on Senate Bill 27, we have to start over from the beginning. All right. Senators Moreno, Buckner, Gonzalez, Fields, Gardner, Cook, Scott, Story, Pedersen, Winters, Janal, Liston, Kirkmeyer, Woodward, Priola, Rankin, Coram, Sonnenberg, Simpson, Hawkes Lewis, Heisey, Kolker, Lee, Lundeen, Gardner, I think I got you. Senator Gardner, please add the president. Please add President Garcia. Senator Priola, we already had you. That should. Yep. With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, Senate Bill 26 is passed. Co-sponsors on Senate Bill 26. Senators Scott, Heisey, Woodward, Moreno, Zenzinger, Cook, Lundeen, Liston, Coram, Rankin, Priola, Sonnenberg. Third reading of bills, final passage. Will the clerk please read the title to Senate Bill 58?
Senate Bill 58 by Senator Simpson, Representative McCormick, concerning the creation of a peer health assistance program for dental hygienists.
Senator Simpson.
Thank you, Madam President. I move Senate Bill 58 on third and final reading and ask for an aye vote.
Is there any further discussion on Senate Bill 58? The motion is the passage of Senate Bill 58. Are there any no votes? No votes on Senate Bill 58. Minority Leader Holbert. Senators Lundin, Cook, Gardner, Kirkmeyer, Woodward, Sonnenberg, Smallwood. With a vote of 26 ayes, 8 noes, 0 absent, and 1 excused, Senate Bill 58 is passed. Co-sponsors on Senate Bill 58, Senators Janal, Kolker, Moreno, Hawkes Lewis, Hanson, Story, Pedersen, Lee, Winter, Buckner, Coram, and Fields. Will the clerk please read the title to Senate Bill 52?
Senate Bill 52 by Senators Hawkes, Lewis, and Smallwood, Representative Mullica, concerning aligning medical assistance income eligibility requirements with federal law.
Senator Hawkes Lewis.
Thank you, Madam President. I move Senate Bill 052 on third reading and final passage and ask for your aye vote.
Is there any further discussion on Senate Bill? Senator Smallwood.
Thank you, Madam President. And so I mentioned this briefly on second reading, and I just want to re-emphasize for perhaps some who are still a little confused, maybe not so much in this room, but out of this chamber, because on this particular bill, I still have received some emails and phone calls, had personal conversations with folks asking, why are we expanding Medicaid eligibility in the state of Colorado? And if you reread or reread the bill, you'll find that that is not what we are attempting to do in this bill. So I have here, and happy to share with you, a letter from the Office of the State Auditor dated February 12th, 2019. And so basically what the state auditor found was that the our local Medicaid provider, the Office of Healthcare Policy and Financing, was following federal rules when it came to determining eligibility. Unfortunately, what was in our statute conflicted with that, and our statutes were not permitting this agency to actually follow those federal rules, those federal requirements. So our state auditor, nonpartisan office, again, which I'm the chairperson of our legislative audit committee, our auditor wrote a letter to Medicaid, and in that letter it says, during our testing of Medicaid eligibility, we found the following errors. During our test work, we found income thresholds in the Colorado Revised Statutes and the Code of Colorado Regulations are not in line with the income thresholds that the Centers for Medicare and Medicaid Services has approved and that the department is currently using to determine eligibility. Therefore, and I'm skipping a part, therefore, the department should ensure that income thresholds outlined in state regulations are in alignment with approved CMS income thresholds. Therefore, for the Medicaid provider here in our state to comply with federal rules, with federal regulations, with federal laws, we need this language change. We need this statute change simply to align the two. So again, I know it's somewhat of a confusing conversation. If anybody has questions, they can come to good Senator from Boulder County and I. We can show you the letter from the audit committee that shows that this is not us arbitrarily expanding Medicaid in the state of Colorado. This is doing what we have to do per the auditor's request. And I would really ask for my colleagues' support with a yes vote on this bill. Thank you, Madam President.
Any further discussion? Seeing none, are there any no votes on Senate Bill 52? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, Senate Bill 52 is passed. Co-sponsors on Senate Bill 52. Minority Leader Holbert. Senators Hansen, Moreno, Rankin, Priola, Kolker, Buckner, Story, Woodward, Pedersen, please add the president. General orders, second reading of bills, consent calendar. Senator Rodriguez.
Thank you, Madam President. I move the Senate resolve itself into the Committee of the Whole for consideration of general orders, second readings of bills, consent calendar.
You have heard the motion. All those in favor say aye. Opposed, no. The motion is adopted, and the Senate will resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills, consent calendar, and Senator Rodriguez will take the chair.
You can stay here. The committee will come to order and the Colt rule is relaxed. Will the clerk please read the bills of all the bills on the general order, second reading of bills consent calendar?
Senate Bill 30, Senators Donovan and Sonnenberg, Representatives McLaughlin and Catlin, concerning the expansion of the Water Resources Review Committee to the Water Resources and Agricultural Review Committee. Senate Bill 20, Senators Gardner and Representative Tipper, concerning the addition of court reporters to the list of professionals who may administer oaths. Senate Bill 91, Senators Buckner and Cook, Representatives Harrod and Van Winkle, concerning making non-substantive changes to language and statutory provisions relating to the review of executive agency rules and in connection therewith repealing obsolete and redundant statutory provisions and conforming other statutory provisions to modern drafting practices.
Majority Leader Fenberg.
Thank you, Mr. Chair. I move for the adoption of all the bills on the consent calendar, which includes Senate Bills 30, 20, and 91, and there are no committee reports.
Is there any discussion on any of the bills of the consent calendar? The motion before the body is the adoption of all bills on general orders, second reading of bills consent calendar. All those in favor say aye. Opposed, no. The ayes have it, and the bills are adopted. Majority Leader Fenberg.
Thank you, Mr. Chair. I move the committee rise and report.
The motion is for the committee to rise and report. All those in favor say aye. Opposed, no. The ayes have it, and the motion is adopted. The committee will rise and report.
The Senate will come to order. Senator Rodriguez.
Thank you, Madam President. The committee has had a number of bills under consideration. Will the clerk please read the report?
Madam President, your Committee of the Whole begs leave to report that it has had under consideration the following attached bills, being the second reading thereof, and makes the following recommendation thereon. Senate Bill 30, Senate Bill 20, Senate Bill 91, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage.
Senator Rodriguez.
Thank you, Madam President. I move the report.
The motion is the adoption of the Committee of the Whole report. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, the Committee of the Whole report is adopted. Senate Bill 30, Senate Bill 20, and Senate Bill 91 passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. General orders, second reading of bills. Senator Rodriguez.
Thank you, Madam President. I move the Senate resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it, and that motion is adopted, and the Senate will indeed resolve itself into the Committee of the Whole for the consideration of we'll try that one again. The Senate will resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills, and Senator Rodriguez will take the chair.
The committee will come to order and the Colt rule is relaxed. Committee will come to order and the court rule is relaxed. Will the clerk please read the bill to Senate Bill 22-54?
Senate Bill 54, Senators Zenzinger and Kirkmeyer, Representative Tone, concerning the addition of a recommendation that a district public school be converted to a community school if the district public school fails to make substantial progress under its turnaround plan.
Senator Zenzinger.
Thank you, Mr. Chair. I move Senate Bill 54 and ask for an aye vote.
Is there any discussion on the bill? Seeing none, the motion is the adoption of Senate Bill 54. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and that bill is adopted. Will the clerk please read the title to Senate Bill 28?
Senate Bill 28, Senators Simpson and Sonnenberg, Representatives Roberts and Catlin, concerning the creation of the Groundwater Compliance Compact and Sustainability Fund.
Senator Simpson.
Thank you, Mr. Chair. I move Senate Bill 28.
To the bill. Okay, so is there any further discussion? Seeing none, the motion before the body is adoption of Senate Bill 28. Oh, Senator Simpson, sorry. Moved over, I lost him.
Thank you, Mr. Chair. So, a little bit about Senate Bill 28. My good friend, the senator from Sterling, and I started this conversation towards the end of last session, thinking about the unique challenges presented to two basins in this state, particularly Division 3 of Water Resources, which is the Rio Grande Basin and the San Luis Valley, and the Republican River Basin, and some of the, again, unique prescribed challenges that each of us have. The Republican River has a compact agreement with Kansas and Nebraska. Colorado's committed to retiring a number of groundwater irrigated acres in the Republican River Basin. The community and the Republican has really worked over the last decade assessing themselves easily in excess of $100 million to solve this problem and be in compliance with their compact agreement. They've struggled to get to the end game of where they need to be. So my good friend, the senator from Sterling, and I started talking about what we have in common, where in the Rio Grande Basin in Division 3, we also have compact obligations, but unique to us in the San Luis Valley, under statute, under 3792-501, the state engineers really authorized to promulgate rules and regulations in the San Luis Valley in Division 3. And to note, in regulating an aquifer or system of aquifers in Division 3, the state engineer shall apply the following principles. Use of the confined and unconfined aquifers shall be regulated so as to maintain a sustainable water supply in each of the aquifer systems, with due regard for the daily, seasonal, and long-term demand for underground water. This is a unique requirement in Colorado and really in the western U.S. to create and maintain a sustainable aquifer system. So much like the Republican River and their efforts about compact compliance, the Rio Grande and the San Luis Valley has been working for a decade to create and maintain sustainable aquifers, really assessing themselves fees in excess of $70 million to solve this problem, this statutory requirement. Mother Nature has not been very kind to us over the last 20 years. I think the headlines in the Denver Post this morning talks about this is a 22-year stretch that's really unprecedented in the last 1,500 years. So we put forward this idea knowing there were federal dollars potentially coming available to help in regard, ARPA dollars in particular, to help the two basins. And I might highlight there are only 4 water conservation districts in the state of Colorado. The Rio Grande Water Conservation District, the Republican River Water Conservation District, the Colorado River Water Conservation District, and the Southwest Water Conservation District. There are only 4 water conservation districts in the state. So here's an opportunity to create, so the bill just creates a fund inside CWCB to accept money, and the idea was we think there's federal dollars available to us to funnel into this fund to help these two communities really, I don't know if you can actually say it's going to solve the problem for them, but it will certainly move us further in the direction of compliance with compact and statutory requirements. So the fund doesn't have an appropriation assigned to it. Again, we're working through the process in Economic Recovery Task Force to identify some funding potentially if we get the fund set up, and then monies, and then through a collaborative effort with CWCB, the state engineer, and those two river district boards, come up with opportunities again to help the two of us move this process much further along. This has been a very collaborative effort with the Department of Natural Resources, CWCB board, the state engineer and Division of Water Resources, and the Department of Agriculture as well. So we all came together over the last summer. This is actually an interim Water Resources Review Committee bill that was passed with unanimous consent out of interim committee. It was also unanimously supported in Ag Committee last week. So that's a little bit of the background and the challenges that we face in our two communities, and the consequences are substantial. If we're not successful in this regard, it's going to be hugely impactful to these two areas of the state that depend real heavily on irrigated agriculture, and in particular groundwater irrigated agriculture. In the Rio Grande Basin, there's, we run the risk of losing the ability to irrigate over 170,000 acres in our basin. If we don't solve this problem in the next 10 years, the state engineer's authority is to turn those wells off. And likewise in the Republican, those communities that rely so heavily on irrigated agriculture as their economic base are really at risk. This is just a wonderful opportunity to take advantage to some federal dollar one-time funding to help us with this effort. Now?
Is there any further discussion? Seeing none, the motion before the body is the adoption of Senate Bill 28. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the bill is adopted.
Thank you.
Will the clerk please read the title of Bill, Senate Bill 22-023?
Senate Bill 23, Senators Gonzalez, Representative Bacon, and Gonzalez Gutierrez, concerning prohibiting deceptive tactics during interrogation of a juvenile.
Senator Gonzalez.
Thank you, Mr. Chair. Colleagues, I bring before you Senate Bill 23 for your consideration today. I move Senate Bill 23 and the Judiciary Committee report.
To the committee report, Senator Gonzalez.
Thank you, Mr. Chair. In the Judiciary Committee, we heard a number of incredibly powerful testimonies, and we also made a number of amendments to the bill in order to respond to concerns that had been raised from the Colorado District Attorney's Council, as well as the Fraternal Order of Police. We updated the definition of agent. We clarified language to ensure that we were only addressing custodial interrogations. And in order to the response from the Fraternal Order of Police that they needed time to train and implement their officers in regards to deceptive interrogation of juveniles, we extended the timeline for implementation to February 28th, 2023. I ask that the body approve our Judiciary Committee report.
Is there any further discussion? On the committee report, seeing none, the motion is the adoption of the Senate Bill Committee Report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the report is adopted. To the bill, Senator Gonzalez.
Thank you, Mr. Chair. Colleagues, I bring for your consideration Senate Bill 23. This is about, the root behind this bill is really about building and restoring trust between community and law enforcement. You all may be aware of the case of the Central Park Five, the case in which in New York, law enforcement lied to children. And 5 young people confessed to crimes that they did not commit. One of those individuals who was later exonerated is a young man by the name of Corey Wise. And he created, in partnership with the University of Colorado at Boulder, the Corey Wise Innocence Project, in order to ensure that no one else has to endure the situation that he and his friends had to endure. We heard testimony in committee from several people who had actually had to endure that very same experience. We heard from a young man, Lawrence Montoya, who lived in my district, in my community. He was interrogated and ultimately falsely confessed to a murder he did not commit and served 14 years in the Department of Corrections before DNA evidence exonerated him. We heard from other people, Ms. Amber Doggett, who testified that during her interrogation from law enforcement officials, even though she knew not to be true that her father had sexually assaulted her, because the police were telling her that she did, she thought, maybe I did, and I just don't remember it. We heard testimony from another individual who shared his experience of law enforcement interrogating him and he had found his parents both stabbed, and during the interrogation that he then had with law enforcement, the police officer told him, "We were able to give your dad an adrenaline shot." He woke up and he said, "My son did this." And for a young boy at the time, a child who trusted both his father and a boy who was raised to trust the police, he said, "Well, if my dad said I did it, I must have done it." Those are the types of interrogations, those are the types of tactics that drive distrust between communities and law enforcement. What Senate Bill 23 would do is it would simply ensure to all parties involved that law enforcement is being truthful, is being honest, is being intentional in its custodial interrogations. The U.S. Supreme Court has recognized that a frighteningly high, and I use that in quotes, frighteningly high percentage of youth falsely confess when facing deceptive police questioning. We heard statistics in committee that nearly of all exonerees, nearly 40% of those exonerations were from youth under the age of 18 who gave false confessions. To be more specific, 49% of those young people were under 21, 31% were children under the age of 18. We had a number, this process of bringing forward this bill from people, working in collaboration with people who have directly had this happen to them, who have lived this experience. I was taught to trust law enforcement, and so when they said I did something, I guess I must have done it. We heard testimony from a professor who specializes in the physiological relationship between trust and the juvenile brain. And we heard that due to that general immaturity at that age, and also reacting to a high pressure situation, like an interrogation with a law enforcement official, the young people will falsely confess in order to try to get out of that high pressure situation. And we also had a number of really productive conversations with law enforcement about this bill. We alternately heard that this doesn't happen, so there's no need for the bill, all the way to this would never happen, so there's no need for the bill. But it's in that spirit of trying to work together and trying to find a meaningful way forward in order to ensure that community and that the citizens of Colorado can trust their law enforcement officials, that we've worked hard to bring a number of amendments for your consideration to try to address the concerns and to make this policy workable for everyone involved. And so there were a number of good conversations that I've been able to have with my colleagues. And I'd like to begin. We do have a couple of amendments that I'd like to offer now at this time. But I do want to express my gratitude to everyone who's testified regarding this policy in committee, and to everyone who has brought forth their thoughts and concerns and amendment language to try to ensure that at the end of the day, that kids in this state can trust law enforcement officials. With that, Mr. Chair,
Okay. There is an amendment at the desk. Will the clerk please read Amendment L014?
L014.
Senator Gonzalez.
thank you, Mr. Chair. Colleagues, Amendment L014.
Would you please move the amendment?
Thank you. Amendment L014. This is actually, let me move Amendment L014 to Senate Bill 23. Jesus.
Is there any further discussion on Amendment L01? Oh, Senator Gonzalez.
Thank you, Mr. Chair. Now that I have properly moved the amendment, because it's the first amendment that I'm moving this session, I'd now like to speak to Amendment L014. What this does, colleagues, is it amends the printed bill, page 2, lines 5 and 6, and it strikes the language, "and any fruits." Now, to those of us who live in the Judiciary Committee, or to those of you all who are practicing attorneys, you all are quite familiar with the language around the fruit of the poisonous tree. And that's a concept that is pretty often discussed within the Judiciary Committee and between lawyers. And so when we were drafting this bill, it all made perfect sense that a statement or admission of a juvenile and any fruits made as a result, that made total perfect sense. But out of context and on the plain black letters of the white paper of Senate Bill 23, we realized that perhaps any fruits was a little bit extraneous language. And so the bill strikes that language, and then on page 2, line 7, strikes the word "are" and substitute "is." I ask for an aye vote.
Senator Gardner.
Thank you, Mr. Chair. Colleagues, I appreciate the offering of this amendment by the senator from Denver. This is a significant and important change by essentially removing I'm trying to think of layperson ways to express this. Whenever there is an illegal search or seizure under Supreme Court precedent for violation of Fourth Amendment, anything that flows from that is also prohibited. This bill goes beyond the protection of the Fourth Amendment, in my view. And so it's appropriate that we don't extend the inadmissibility. So if somehow a confession were prohibited, nevertheless, the things that law enforcement might be led to as a result of that confession in support of the case would remain admissible. So I think this is a significant change. I support this amendment, and I thank the sponsor for offering this amendment.
Seeing no further discussion, the motion is adoption of Amendment L014. All those in favor say aye. Opposed, no. The ayes have it, and the amendment is adopted. Is there any further discussion on Senate Bill 23? Senator Cook.
Thank you, Mr. Chair. I rise in opposition to this bill for many reasons. The sponsor talked about trust with the community. You know what causes distrust in the community with law enforcement? Is law enforcement not being able to solve their case. Not being allowed to use the tools that they are allowed to under the Supreme Court. And here we go again. Just when you thought it was safe to get back in the water, when we thought all the anti-law enforcement bills that could be heard last year are being heard now again. This is another bill, an anti-law enforcement bill that ties the hands of law enforcement. It puts criminals over victims once again. I can't believe we're hearing a bill that, again, puts criminals over those of victims. You know, the bill is not needed for several reasons. We did hear testimony from somebody that confessed to a crime that he didn't commit, but that was several years ago. I believe it was in 2014. And since that time, a lot of safeguards have been put in place for juveniles. One, 163601, already required for F1 and F2 and felony sex assaults be videotaped, be recorded. Plus, we passed all the legislation last year about body-worn cameras. A new safeguard that was put in just a couple of years ago is that during a custodial interrogation, both the parent and guardian have to be physically present. So the parent has to be with the juvenile. Both the juvenile and parent guardian must be advised and waive their Miranda warning. Once raised, prosecution must show by preponderance of the evidence that there was no interest, that the parent had no alternative interest with the juvenile, and was able to provide protective counseling. Voluntariness of juvenile statements in custodial interrogations, once raised, once raised by the defense, prosecution must show by preponderance of the evidence statement was voluntary. So it takes into consideration, the judge has to look at, well, was this statement voluntary or was it involuntary? If it's involuntary, it gets thrown out. So we don't need this bill to tie the hands of law enforcement. The court also looks at the totality of the circumstances, including factors, age, experience, background, intelligence, capability of understanding warnings given, the nature of the Fifth Amendment rights, consequences of waiving those rights. The judge looks at all those things and again determines, was the statement voluntary or involuntary? It has to have clear and convincing standards in an atypical criminal law case. What that means is the burden is already on the prosecution. Again, we are passing a bill when we have a crime epidemic. We all know how bad the crime is in this state right now. A lot of it because of what the bills that get passed in this chamber and the other chamber. We're at an all-time high, a 40-year high of crime in this state, this city, and our communities. And yet we want to make juveniles protected even more than what they already have the rights for. And we want to punish law enforcement for a viable tool that they can use. In case you're wondering, let me tell you some of the crime stats of juveniles from 20 to 21. Violent crime, up almost 19%. Murder, up 10.5%. Aggravated assault, almost 31% committed by juveniles. Non-consensual sex offenses, up 17%. And now we want to punish law enforcement to not use a tool that in their tool belt. I have a letter here from the Colorado Fraternal Order of Police. And you would say, you know, well, this is trying to build trust with the community. No, it doesn't. Again, it causes distrust. Because law enforcement can't do their job. The citizens don't come to us and say, hey, you know what? I don't have trust with the law enforcement because you guys passed these bad laws. They go to law enforcement. I don't trust you because you can't solve my case. Let me give you a couple examples of what this bill might do if it gets passed. Can't use any deception. Let's say you have a juvenile suspect that is at the scene of a crime, and he tells law enforcement, don't Make no mistake, kids lie to law enforcement all the time. And the law enforcement officer says, hey, we know you were there. And then the officer might not know the person was there. But he says, hey, I know you were there. And the juvenile says, okay, yeah, you got me. I was there. That statement now could be thrown out because there was deception when the officer said, we knew you were there. This is how broad this bill is. We knew you were there when we might not have known. Let's take a hypothetical. Oh, a couple of 3, 4 gangbangers in a car driving by a high school, shoot 6 students. And law enforcement says, hey, to one of the suspects, hey, your buddy, which is this common practice, I mean, in some cases, in a case like this, when you don't know who the shooter is, you say, hey, your buddy said you pulled the trigger. When maybe you don't know. And that person says, hey, no, I didn't. This other guy did. And I can lead you to other information. I can lead you to other evidence. Now that statement will be thrown out. Sometimes you have to use deception to get to the truth. The Supreme Court said it was okay. The U.S. Supreme Court. And I believe the good senator from Colorado Springs is going to talk about that a little bit. And I use this as an example in committee. You have a serious crime. Murder, a rape, whatever. And the juvenile comes in to the interrogation and says, no, I wasn't there. I have an alibi. I said, okay, what's your alibi? Oh, I was at a matinee at a movie theater. I wasn't in that car that shot those 6 students at a high school. I was at a movie theater watching a movie. And the officer says, okay, so you were at this movie at this time. So you were there when the fire alarm got pulled and they had to evacuate the building. Okay, so a little bit of deception there. But you want to get to the truth. Do you want to validate that, that statement? You want to prove it right or you want to prove it wrong? And if he comes back and says, yes, I was there when they pulled the fire, somebody pulled the fire alarm and had to evacuate, then you know that alibi is no good. But yet you can't even do that under this bill. Again, we're punishing law enforcement at a time when crime is an all-time high. Let me ask you this. If it was your child that was kidnapped, raped, murdered, wouldn't you want law enforcement to be able to use every tool that they have at their disposal to solve that crime, to get your child back who might have been kidnapped? Do you want to take that tool away from them if it was your child? Well, maybe that's different if it's our children, but other people, we're putting the criminal juvenile over the rights of the victim once again. Again, I mentioned I had a letter from Fraternal Order of Police, and I'd like to read parts of it. Because the good senator from Denver mentioned the FOP and working with them. They are in total opposition, as is all of law enforcement. But again, it's just law enforcement, so it doesn't really matter. The Colorado Fraternal Order of Police, FOP, opposes 22023 as written. The FOP does not believe that this single nuanced interview tactic should be regulated by state statute. Deception of a juvenile is not appropriate in every situation, but it is a critical tool in certain scenarios for providing safety and justice to crime victims, including other juveniles. Again, if it was our child, I think we wouldn't care how we got our child back. Including other juveniles and the general public in what can unfortunately be very violent crimes. We do not support the blanket removal of effective tools from law enforcement rather than efforts to improve them. We feel that a more nuanced approach of looking at ways to implement best practices on juvenile deception would more effectively address shared concerns about avoiding false confessions while acknowledging that there are situations in which this tactic is appropriate. like finding a kidnapped child, finding a murderer. We would be more comfortable with an approach that convened experts to delve deeply into the tactic to develop best practice guidelines that allow for a more targeted approach to when and how deceptive information should be used in juvenile interviews. Requiring agencies to have evidence-based policy on this tactic would be a more balanced solution than an outright ban, which will have consequences of its own. We also share the many concerns expressed by other law enforcement colleagues about the confusing and undefined nature of some of the language in the proposed legislation, including terms like false beliefs. The letter goes on, but you get the gist. Again, colleagues, let's stand up for victims for once. Let's say, hey, victims, you have rights. Especially during this time when we're having an epidemic of crime in this state. Colleagues, I'd ask for a no vote on this bill. Thank you.
Mr. Chair.
Senator Gonzalez.
Thank you, Mr. Chair. And thank you to the good senator from Weld County for his comments. I just want to respond a little bit to his comments, because the viable tool that he is referring to is lying to children. In our criminal justice system, as I will remind you all, you are presumed innocent until proven guilty. And in the scenario he outlined, those actually mirror quite closely the facts of Mr. Lawrence Montoya's case. In his comments, he's conflated the Miranda advisements with the voluntariness of the statement. And colleagues, in his case, and in nearly every single other false confession DNA exonerations that happen due to DNA evidence after there was a false confession elicited during custodial interrogations with the law enforcement officials. The judge found in every single one of those instances that, well, the confession was voluntary, so we're going to allow it. That's what happened in Mr. Montoya's case. And those safeguards that folks have pointed to are insufficient. I've had some conversations with colleagues who have said, well, it doesn't happen that much. One innocent person who is sitting in the who sat in the Department of one innocent person who sat in the Department of Corrections while the real murderer was out roaming the streets. That's what's at stake here. In the case of law enforcement feeling like the only viable tool of utilizing deceptive tactics in order to find a kidnapping victim, If that is what they need to do in order to go and find that child, that is completely permissible under Senate Bill 23. Especially now that we've struck the language "and any fruits." It's perfectible. It is absolutely admissible under this bill. It's just that if they don't find any other shred of evidence at the crime scene, which, because I believe in our law, the capacities and capabilities of our law enforcement officials, I am sure that they will be able to do. DNA evidence, concrete hard evidence, they won't need to utilize solely a false confession obtained utilizing these deceptive tactics. Colleagues, I ask for an aye vote on this bill.
Senator Cook.
Thank you, Mr. Chair. Well, first off, it's not the only tool. I don't believe anybody's ever said that the only tool law enforcement has in their tool belt is deceptive interrogation practices. It is a tool. It is one of many tools. It might be the only tool that could solve a case. And again, I repeat, it is not permissible under this bill. Whether or not you take out the fruits of any fruits, the fruit of the poisonous tree, all that. Line 7, custodial interrogation by law enforcement official or agent is presumptively inadmissible against the juvenile at a subsequent judicial proceeding in the law enforcement official or agent knowingly uses deception prior to or during the interrogation. Presumptively inadmissible. And the prosecution has to establish at the hearing prior to trial by clear and convincing evidence and based on the totality of the circumstances. So we're making it harder for law enforcement. We're making it harder for the victims of a crime by this bill when it's not needed. Again, not conflating anything. We're talking about a case that happened in 2014 when some of these safeguards weren't in place. Judges have the right to say that case, that confession was not voluntary. And we heard about DNA evidence. And some guy from John Jay School of Justice in New York mentioned 3,000 cases where DNA cleared people. And it's in, I forget what database, 3,000 cleared by DNA, 11 from Colorado, 0 juveniles. Yes, DNA is out there. DNA clears people that are wrongly convicted, but they clear people that are wrongly convicted in a lot of different ways, not just through interrogation, by false confessions. Again, safeguards are in place. The parent has to be in the interview, has to be in the interrogation, and they both have to waive their rights. The parent is read the rights, and the parent has to waive the Miranda warning as well. And there's other safeguards like videotape. Again, for once, let's think about the victims. Think about if our kids were a victim of a crime. We're taking away a very valuable tool for law enforcement, in which case evidence could be suppressed.
Senator Gonzalez.
Thank you, Mr. Chair. You know, this policy is passed in 2 other states, and I believe 6 or 7 other states are considering similar legislation. In other states across the country, law enforcement has been largely supportive of this change. And so one would ask themselves, why would it be different here in Colorado? Because when we look at the data, not only here in Colorado, but across the country, we are seeing a rise in crime rates, both in Colorado and across the country. So why would in other states law enforcement be supportive of this policy? When we're talking about, again, viable tools, why would that be different here in Colorado? That's actually because here in the state of Colorado, current law does allow for the conviction of a child based on their confession alone, without any other corroborating evidence. Now again, when we look at the data about false confessions coming from juveniles, how do we address that? That's what Senate Bill 23 aims to do. It's merely asking law enforcement to not lie to children. And to the good senator from Weld County, no victim will benefit when the wrong person confesses to a crime they did not commit. I will just close by saying that the International Association of the Chiefs of Police, their, I believe, vice president of training, testified in support of this bill. A decade ago, they condemned utilizing these deceptive tactics in juvenile interrogations. I ask for an aye vote.
Senator Cook.
Thank you, Mr. Chair. Let's set the record straight. Law enforcement across this country does not support this bill. And wow, two states have passed it. Last I counted, we have 50. That would be 48 that have not passed it. And to say that there's 5 or 6 that are considering it, that doesn't mean they're going to pass it. They might say, hey, this is really a bad idea. So 2 states out of 50. That doesn't mean it's a good bill just because 2 states out of 50 passed it. And let me also set the record straight. You can't convict somebody just based on a confession. You have to have other evidence. Supreme Court ruled that. Somebody confesses, that's not enough proof to even to take it to trial. But that confession could lead to other evidence to get a successful prosecution. So again, let's not follow 2 states that passed a bad bill. Let's do what the other 48 have done and said no. So I'd ask for a no vote on this bill.
Senator Gardner.
Thank you, Mr. Chair. Colleagues, particularly colleagues to my right and your left, we have done in the past 2 years, the past 2 sessions, an extraordinary amount of legislation to curb practices in law enforcement. This is another. Before you dismiss what I have to say about this bill, I ask you to think about those other bills and what the general reaction of our constituents has been about bills to defund or constrain or control or somehow deal with law enforcement. And once you do, I hope you will pay close attention to what I have to say here, because I appreciate what the senator from Denver is hoping to do here. There will inevitably be instances around the country, and regrettably, perhaps instances in Colorado, of overreaching by law enforcement. And the reaction is naturally, let's pass a law and let's put a stop to that. Okay. The United States Supreme Court has spent 200 plus years hearing cases to try to rationally put a fence around those things. In 1962, I think, was the year, but I would stand corrected if anyone else knows. In the case of Miranda versus Arizona, the United States Supreme Court decided that voluntary confessions were only confessions after Miranda warnings. Actually, there are other avenues, but they're a practical impossibility. So now everyone in custodial interrogation receives Miranda warnings. But interestingly enough, both in the adult and the juvenile context, the United States Supreme Court did not hold that any deception whatsoever would make a confession involuntary. Why is that? Well, first of all, what does it mean in an interrogation to be deceptive? This bill, let's be really clear, pull this bill out if you don't have it in front of you, or if you don't. It says a statement or admission of a juvenile made as a result of the juvenile's custodial interrogation by a law enforcement official is presumptively inadmissible against the juvenile at any subsequent judicial proceeding if the law enforcement official knowingly uses deception. Doesn't say the law enforcement official lies or coerces or somehow creates abusive circumstances. Any deception. I was just telling the majority leader, when you have two children, you'll learn interrogation techniques pretty quickly. You know? Sometimes you'll ask them together, and sometimes you'll ask them separately who ate all the cookies. I say this in jest, but think about it. When 4 young people are arrested in a car, or that were in a car in Aurora after a shooting, what happens? Well, based on my knowledge and experience, which is not as extensive as the former sheriff's, those 4 young people will probably be picked up because they are suspects. They will each be put in a separate room. And of course, they've already had a discussion about how we're not talking. Now, let's not forget that the reason that they are under suspicion is that someone has been killed, another young person. And they put them in separate rooms. And they're not going to talk because they know if they don't talk, they're not going to be convicted. So what does law enforcement do? They go in the room, and under this bill, I guess they go in the room and say, tell me what happened. I don't know what you're talking about. Nothing happened. Didn't anything happen? Don't know what you're talking about. Now, if the officer says, we know you were in that car. Well, did they know? Did that officer really know they were in that car? See, now we're into this discussion. Did the officer know, or did the officer just suspect? So was the officer being deceptive when he said, I know you were in the car? Because that's what this bill says. Says, if the law enforcement official knowingly uses deception. Well, if I say I know a little bit more than I know, and that I only have suspicion, somewhere in that interrogation, then the next likely thing to be said is, because law enforcement probably does have a very strong idea that that young person was in the car, from a confidential informant that will never be able to be called because their life is at risk. What will the law enforcement officer then perhaps say? You know, your buddies in the other room, you know, they're about to finger you. Wait a minute. Now, is that deceptive? Well, I guess as a lawyer, I could sit there, and I don't believe every law enforcement official should have to have a law degree and some years of practice in direct and cross-examination. I could probably find my way through that and never say anything deceptive, or at least arguably not. When law enforcement has this kind of a problem that they're investigating, they necessarily must use some questioning tactics that cause an individual who's already entered into a pact with his friends. We're not talking. And if we don't talk, nobody's going down. Nobody's going down for the murder of that person in the park. Now, the senator from Denver has cited some cases, and I want you to know that I recognize this issue, and it has to be dealt with, because not every case by any means is a murder in Aurora, in a park, in Denver, in a park, in Colorado Springs, out in a rural area, where at least one young person was at the wrong place at the wrong time with the wrong person when he was murdered by a group, including juveniles. Sometimes it's just taking baseball bats to mailboxes, which is despicable vandalism, but having been raised in a rural area as a simple country lawyer, that happens frequently enough. But it needs to be dealt with. And parents want their children in those situations to walk away eventually feeling that law enforcement was fair, treated them decently, didn't lie to them. And so the bill is not ill-founded, it's ill-considered. What I would like to do is not see Senate Bill 23 defeated. I would like to see Senate Bill 23 be appropriate and effective. And the way to do that is to amend Senate Bill 23 in a couple of ways. And the first way is contained in Amendment L013, which might be on the desk.
There is an amendment on the desk. Will the clerk please read Amendment L013?
Amendment L013
Senator
by...
Gardner,
Thank you, Mr. Chair. I move L013.
would you like to?
The first thing we can do, the first thing we ought to do to Senate Bill 23 is to train our officers in juvenile interview and interrogation and make clear to them and make sure they understand that when you deal with young people, you are not dealing with experienced adults. Senate Bill, Amendment 13 says that the Post Board, this is the Peace Officer Certification Training Board, every officer in Colorado has to be post certified, says the Post Board has the following duties: to develop an in-person interactive training program for peace officers on the implementation of the bill, to ensure uniform interpretation of the law. Let's first of all ensure that our officers are trained. Because we're going to have to do this and impose it on local departments, the state's going to cover agency costs associated with training. And at a minimum, the education for the peace officers would include understanding juvenile development and culture and what that means for interviews. Heard the senator from Denver talk about some of the interrogation and interview tactics that law enforcement uses. You know, if I were interviewed, if I were the subject of a custodial interrogation, let me tell you, I'd say, I'd like a simple country lawyer with me, please. Young people may, many of them, be more subject to persuasion. Some of the training is on interpreting juvenile behavior during the interview and what that means. Techniques, and this one actually, techniques for building and establishing rapport with juveniles. You know, one of the things that interviewing and interrogation includes in many of its techniques is simply establishing a rapport with the person that you're interviewing. I mean, would it be deceptive to say, you'll feel better if you get this off your chest? That's often. Is that deceptive? I don't know. I wouldn't feel better if I got it off my chest and I went to jail for a long, long time. I'm not sure I'd feel better. I wouldn't want to have to litigate that. The amendment goes on about constructing age-appropriate statements, interrogating juveniles, and how to reduce the likelihood of false or coerced confessions. Because, as the senator from Denver points out, it really does no good to get a false confession. Not only is it damaging to the young person who gave the false confession, but you don't solve the crime. So, members, I ask for your support for L013. L013 is an appropriate amendment, no matter what form the bill is in, to ensure that law enforcement is trained, capable, and understands the differences between interviews of adults and interviews of juveniles, and I ask for an aye vote.
Senator Fenberg.
Thank you, Mr. Chair. I request a senatorial 5.
Senatorial 5 has been requested. We'll pause for a second.
She's confabbing with her people, but if she...
If you're going to order any clothing, you need to do so today by 4 p.m.
Senator Gardner, would you like to continue your discussion?
Oh,
We're back.
thank you, Mr. Chair. I renew my motion for approval of L013.
Senator Fields.
Thank you, Mr. Chair, and good morning, everyone. And to the bill sponsor, thanks for bringing this topic up for discussion because it's a very real and important item that deserves our attention. I've been circling around this issue as it relates to truth and justice and truth in policing for a very long time. And when I think about my own children, and I think about my grandchildren, and I think about the title of this bill, which is Deceptive Tactics when a juvenile is in custody and the interrogation approach, it causes me to ponder a little bit. And the reason I ponder about this topic is because it's not equitable. It's not equal. There's a difference between equity and equality. And the reason I say that is because when you see a police officer in a uniform, they kind of command a certain level of respect. I know when I see the police when I'm driving, the first thing I try to do is I look at how fast I'm going. And oftentimes I will slow down. In case you're confused,
Senator Fields, we are.
I am in support of this amendment 023. 013. 013.
013.
I'm in support of this amendment. And let me explain why. Because it's not equal. And I believe that law enforcement does need to have training as it relates to understanding how to interrogate a youth or a juvenile. Because if you just make a blanket statement and just say, go do it, your perception of how to do it in Grand Junction or in Vail or in Telluride or somewhere else might be different. I believe in having standards. I don't want to have this decoupage or potpourri where everyone gets to approach what they believe is a deceptive practice into place. I want to see our law enforcement officers set up for success and not for failure. So basically what that means is we need to have some standards and some objectives in mind when you're dealing with the youth and you're interrogating them. I don't see anything wrong with that. Because we know in those kinds of situations, it's not 50-50. Because in law enforcement, it is an adult-centered approach. And most of the time, the adult has the authority in that room. And there needs to be some acknowledgement of the authority that that law enforcement officer brings into that interrogation room. The dynamics. And when you think about the dynamics, it could be associated with trauma as it relates to how they have experienced the police as a young child or maybe through their parents or whatever. They're bringing in those kinds of feelings, and who knows what is said or how it's going to be approached. But it's not a 50-50, even Steven type of approach. And law enforcement needs to acknowledge that, and they need to make some adjustments and recalibrate their approach when they're dealing with juveniles. Because oftentimes they might not know what they're saying, the long-term impact that might have on their life, on their family's life. Now, when you go through law enforcement training, and I've been around State Patrol training as well as the Aurora Police Department, they give you training on how to de-escalate. They give you training on how to use your gun. They give you training on traffic control. They give you training as it relates to first aid, and the list goes on and on and on. I was down here when a law was introduced, and it did pass, and it was signed by the governor. And it was a bill in reference to how to interact with dogs. Because we had scenarios where the dog was shot. And it was like mandatory training that law enforcement had to do to enact with the dog. We're talking about children here, and I did ask the question in reference to the range of what we're talking about, and I got I don't know. I don't know if it's 17, 18, down to 5, 6, 12. I'm not quite sure if we're talking about kids or children or youth. But what is clear to me is that we need to have a uniform interpretation of the law as it relates to interrogating our youth. I heard some discussions about all that we've done down here under the Golden Dome as it relates to policing and police reform. We've done a lot, and I think that we should be proud of the work that we do and the work that we have done. Those bills have been passed, and they're in the rearview mirror right now. But I think about when we talk about the truth in policing, if we want to have trust in policing, then we need to make sure that everyone is approaching with the same standards. And we're not leaving it up for anyone else's interpretation. We need to have objectives, like you have in most training, where you know what the outcome is, that you understand what cultural sensitivity is like when you're interrogating maybe someone of color or someone with a disability. We've even passed laws down here based on incidents that have happened in Denver when they're dealing with youth, kids, adults, or what have you, that are challenged with behavioral health disorders. Members, I'm asking for your support on this amendment. Why? Because interrogating is tricky and it's challenging. And when you have an adult-centered approach, there is going to be some losers. And if you're not trained to understand and how to handle these tactics, that are culturally sensitive, that creates a criteria of understanding, I think that's a good approach. It's a good idea, but I believe that we should tie training as it relates to this bill, as it relates to interrogating our youth and our children. We need a uniform approach moving forward. I ask for an aye vote.
Thank you. Just to remind everybody, we are still debating Amendment L013. Senator Gonzalez.
Thank you, Mr. Chair. Thank you to the good senator from Colorado Springs for bringing forward L013. I find myself shocked that in addition to having over a year for implementation, law enforcement finds it necessary to ask for additional funds on how to not lie to children during those custodial interrogations. But that being said, I want to state that, all right, let's make sure that that's the place where I'm starting from. And I just want to name that. But I also want to try to listen and hear and appreciate where law enforcement is coming from. And so if they need to develop the in-person interactive training program for police officers that includes information on how to understand juvenile development and culture, and if they need to develop an in-person interactive training that interprets juvenile behavior, and if they need training on techniques for building and establishing rapport with juveniles, and if they need training on constructing age-appropriate statements and questions, and if law enforcement is saying that they need training on cautions and considerations for interviewing and interrogating juveniles, all right, I hear that. I have a bit of concern with putting forward a floor amendment without actually being able to understand what this fiscal impact will be. But I want to be listening to and be responsive to law enforcement. And so, colleagues, I ask for an aye vote on L013.
Senator Janal.
Thank you, Mr. Chair and members. I stand in support of L013, and I want to thank the good senator from Denver for accepting that. Under current law, there's already safeguards, but I think this is a reasonable ask in this amendment. There's just one thing I do want to say that's been implied throughout this whole testimony today, is that police officers and law enforcement are lying to children. And I really think that that's a false accusation. And I don't know how we make it stop, but that is not what I've seen. And interrogation is interrogation, and I haven't seen lies. In fact, I've probably seen it from the juveniles, if you really want to know my personal statements. But to say bluntly and blatantly across the board that all law enforcement that are interrogating juveniles lie, that's a false statement.
Senator Moreno.
Thank you, Mr. Chair, and colleagues, to Amendment L013. I just wanted to extend appreciation for the caution that the good senator from Denver, the bill sponsor, has encouraged us to exercise. As your resident numbers watcher, I also share concern about adding amendments during second reading debate that have an indeterminate fiscal impact. That is something we should all be very mindful of. But also, as a shameless plug, that you all should tune in to the Joint Budget Committee hearings. This afternoon, in fact, we will be conducting figure setting for the Department of Law, which includes the Post Board, and there is a request, budget request R3, to provide additional funding to the Post Board. Some of you may be aware that the Post Board is actually undergoing a curriculum redevelopment for local law enforcement. So in a lot of ways, Amendment L013 is a nice complement to that additional work. I think, colleagues, though, we will have to watch whether or not they can conduct that curriculum redevelopment within existing resources, or perhaps the resources that could be granted by budget request R3, or whether a separate appropriation is actually necessary to encourage this type of curriculum and this type of training. So again, just want to encourage us to exercise budget prudence in this situation, but know that there is an action item for additional resources that perhaps L013 might complement nicely.
Seeing no further discussion, the motion for the adoption of Amendment L013, all those in favor say aye. Opposed, no. The ayes have it, and Amendment L013 is adopted. Senator Gardner.
Thank you, Mr. Chair. And I appreciate the very cogent discussion on the prior amendment. Senate Bill 23 has an infirmity in that it is incredibly prescriptive. It says a statement or admission of a juvenile made as a result of the juvenile's custodial interrogation by a law enforcement official or agent is presumptively inadmissible against the juvenile if the law enforcement official uses deception prior to or during the interrogation. And it sweeps with a lot of what I will call blanket prescription, prohibition. inadmissibility. Now, juvenile covers a broad range group. You know, could be 12, could be 18. Not quite 18, 17 and 364 days, because the law likes bright lines. And if you're 17 years and 11 months, if you're 17 years and 364 days, you're still a juvenile. And what's appropriate with a 12-year-old, 13-year-old, and what's appropriate with someone who's effectively 18 are wholly different. And yet the bill says if there's any deception at all. And by the way, I have to say the lawyer me really kind of likes the bill, but not for reasons that you ought to be voting for it. The lawyer me really likes the bill because it creates a lot of work for lawyers. If you want to create a lot of work for lawyers, well, you know, you might want to vote for the bill. But if you're like me, I don't really want to create more work for lawyers for the sake of doing so, because there's going to be all sorts of litigation around what is a deceptive statement and what isn't a deceptive statement, and motion after motion. The way to deal with that is to set a standard with respect to voluntariness of confessions by juveniles that takes into account the standards that the United States Supreme Court has imposed. And the court says that you need to look at the emotional and developmental differences between adults and juveniles, that law enforcement has to take those differences into account when conducting an interview or custodial interrogation of a juvenile. And frankly, departments need an internal policy about how to observe the legal rights. This goes with the training. There ought to be a policy by every department, police and sheriffs, about how to observe the legal rights of juveniles and the voluntariness of confessions. They should not be coerced or intimidated. There's a far cry difference between telling a 16 or 17-year-old that you don't want to be the one that goes down for this, that your buddy in the next room is going to give you up, and causing that young person to think about, you know, I'm hanging out here. Why should I be going down for the guy in the room next to me? After all, he was the one that pulled the trigger. It wasn't me. That might be a felony murder. I don't know. I'll leave that to the other senator from Colorado Springs to talk to that. Those kinds of situations are common. All too common, unfortunately. Another thing to do is to adopt written policies or procedures for custodial interrogation. Those are the things that will matter. Those are the things that will make it possible to control law enforcement, not throwing out confessions that are properly obtained, not throwing out confessions that are valid confessions, because that's what's going to happen the way that Senate Bill 23 is written right now. That's the concern that the letter from the Fraternal Order of the Police is about. They say we would be more comfortable with an approach that convened experts to delve deeply into the deceptive tactic and develop the best practices guidelines. Deception of a juvenile is not appropriate in every situation, they say, but it is a critical tool in certain scenarios for providing safety and justice to crime victims, including other juveniles. As well as the general public for what can be very violent crimes. And I point to crimes that happened this past year in Denver and Aurora, in Colorado Springs, most likely in Pueblo, although I can't point to a particular instance there. These are all too common, juvenile crime around the state and all of our major communities. This more nuanced approach is represented by an amendment I have, which might be at the desk. I don't know.
There is an amendment at the desk. Will the clerk please read Amendment L015?
Amendment L015 by
Gardner.
Thank you. Mr. Chair, I move L015. L015 speaks to the things I was just talking about. It addresses those things by replacing the language of prohibition in Senate Bill 23, making things inadmissible, and instead would read a statement or admission of a juvenile made as a result of the juvenile's custodial interrogation by a law enforcement official or agent must be considered against the standards of the United States Supreme Court for voluntariness of confessions by juveniles. More than anyone in this room, the United States Supreme Court has given a great deal of thought to this and a great deal of briefing and discussion of the nuances around this. This is a solid approach. This is an approach that both protects juveniles and protects the community. The fight for so many of our law enforcement bills over the past 2 years have been about the protection of perpetrators, suspects, and defendants, and the general public safety. I submit to you that concern out there that my friends and colleagues on my right and your left are talking about today are precisely because that balance has not been properly struck. L015 does strike the right balance, does protect juveniles. It's intended to protect juveniles, and with the training piece will make the difference and provide the assurance to the public that confessions are not coerced, they're not gained by intimidation. I ask for an aye vote on L015.
Senator Gonzalez.
Thank you, Mr. Chair. I do just want to acknowledge that L015 is about as close to a strike below and gutting of this bill that I could see. I ask for a no vote.
Is there any further discussion? Seeing none.
Division.
A division has been called. All those in the chambers entitled to vote, please be seated. Wait for the motion. All be seated.
Slow down, homie.
I just wanted to get everybody back for announcements.
There was something about if this amendment was passed that we would move along.
We did?
No, the last one. The last one.
I have some important announcements.
Absolutely ignore it. It's fine, but you specifically said you were not.
Well, it's a bit of a-
No, I need people to stick to their word.
Okay, for all those in favor of support for L015, please stand.
Brittany's definitely standing. She's totally standing.
Please be seated. All those opposed, please stand. We had oh. The motion for the adoption has failed. The amendment fails. Senator Gonzalez.
Thank you, Mr. Chair. I appreciate the conversation that we've had here this morning on this bill. I renew my motion for passage of Senate Bill 23.
Senator Cook.
Thank you, Mr. Chair. I do want to clear up one thing, too, because it was said that the IACP would be in support of this because in their model policy, they say you can't be deceptive. Okay, because I believe the good senator from Denver is going to clarify, because that's not what the policy says, and I was prepared to read it and explain it. But IACP does not say anywhere that deceptive interview techniques is wrong and shouldn't be done. So I just want to clarify that, and I appreciate the senator clarifying it as well.
Senator Gonzalez.
Thank you, Mr. Chair. Thank you for that, Senator, to the good senator from Weld County. I misspoke when I was naming the person who testified. I actually meant to refer to Dave Thompson, the head of Wicklander Zulawski, the second largest police training organization in the country. Thank you. I apologize, and thank you for correcting that.
Is there any further discussion? Seeing none, the motion is for the passage of Senate Bill 23. All those in favor say aye. Opposed, no. The ayes have it. Senate Bill 23 passes. Majority Leader Fenberg.
Thank you, Mr. Chair. I move the committee rise and report.
The motion before the committee is to rise and report. All those in favor say aye. Opposed, no. The ayes have it, and the committee will rise and report.
You want to lay over your resolution?
The Senate will come to order. Senator Rodriguez.
Thank you, Madam President. The committee has met and had a number of bills under consideration. Will the clerk please read the report?
Madam President, your committee of the whole begs leave to report it has had under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. Senate Bill 54, Senate Bill 28, Senate Bill 23 is amended, passed on second reading, and ordered, engrossed, and placed on the calendar for third reading and final passage.
Senator Rodriguez.
Thank you, Madam President. I move for the adoption of the report.
Minority Leader Holbert for discussion or as a no?
Discussion.
Minority Leader Holbert.
Thank you, Madam Chair. Request a senatorial 5.
The Senate will stand in a brief recess. The Senate will come back to order. Who do I?
Rodriguez.
You have to move the report.
Senator Rodriguez, just to refresh us where we are, can you please move for the adoption of the Committee of the Whole report?
Thank you, Madam President. I move the report.
The motion is for the adoption of the Committee of the Whole report. There is an amendment on the desk. Will the clerk please read Amendment 001 to the Committee of the Whole report?
Amendment 001 to the...
Clerk, please turn your mic on.
Senator Fenberg moved to amend the report of the Committee of the Whole to show that the following Senator Gardner falling...
Keep reading it.
Floor Amendment L015 to Senate Bill 23
Senator
did...
Gardner.
Thank you, Madam President. I move Cal Amendment 1 to Senate Bill 23. Ask for an aye vote.
Senator Gonzalez, discussions on Committee of the Whole Amendment 1.
Thank you, Madam President. Respectfully, I ask for a no vote on this Cal amendment.
Further discussion. The question before the body is the adoption of Amendment 001. Are there any no votes? Senators Gonzalez, Fields, Moreno, Kolker, President Garcia, Senators Lee, Buckner, Winter, Story, Pedersen, Zenzinger, Janal, Rodriguez, Hansen, Hawkes Lewis, Coleman, Majority Leader Fenberg, Senator Bridges. Please add the President. With a vote of 15 ayes, 19 noes, 0 absent, and 1 excused, that amendment is lost. The question before the body is the adoption of the Committee of the Whole report. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, that Committee of the Whole report is adopted. Senate Bills 54, 28, and 23 as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. Consideration of resolutions. Majority Leader Fenberg.
Thank you, Madam President. I move consideration of resolutions, which just includes Senate Joint Resolution 002, layover until Wednesday, February 16th.
The motion is to lay over Senate Joint Resolution 2 until tomorrow. All those in favor say aye. Those opposed, no. The ayes have it, and Senate Joint Resolution 2 will lay over until February 16th. Governor's appointments consent calendar. Will the clerk please read all the appointments listed on the consent calendar?
Members of the State Board of Stock Inspection Commissioners for terms expiring May 1st, 2025, Lorraine Francis Bonds of Durango, Colorado, to serve as a representative of the non-confinement cattle industry. Appointed Marguerite Parker of Firestone, Colorado, to serve as a representative with broad knowledge of Colorado livestock industry and shall represent commodity other than confinement and non-confinement cattle industries with the largest percentage of charged fees. Appointed members of the Colorado Wildlife Habitat Stamp Committee for a term expiring December 31st, 2022. Lauren McCain of Denver, Colorado, to serve as a representative of national regionally recognized conservation organizations whose mission is focused on non-game wildlife and whose membership is composed primarily of non-game wildlife users, occasioned by the resignation of Ashley Johnson Russell of Denver, Colorado. Appointed for a term expiring December 31st, 2023. Erica Elva of Englewood, Colorado, to serve as a representative of national regionally recognized conservation organization whose mission is focused on non-game wildlife and whose membership is composed primarily of non-game wildlife users, occasioned by the resignation of Priya Yanyapa of Lakewood, Colorado. Appointed for terms expiring December 31st, 2024. David Gottenborg of Jefferson, Colorado, to serve as a landowner actively engaged in agriculture. Appointed David Warsh of Center, Colorado, to serve as a landowner actively engaged in agriculture. Appointed for a term expiring December 31st, 2025. James Travis Black of Grand Junction, Colorado, to serve as a representative of Division of Parks and Wildlife, who is also a wildlife biologist. Appointed.
Majority Leader Fenberg.
Thank you, Madam President. I move for the confirmation of all the appointments listed on the consent calendar, which includes members of the State Board of Stock Inspection Commission and members of the Colorado Wildlife Habitat Stamp Committee.
Is there any discussion? The motion is the confirmation of all the appointments on the governor's appointment consent calendar. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, all the appointments are confirmed. Committee reports.
February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1170 be referred to the Committee of the Whole with favorable recommendation, with the recommendation that it be placed on the consent calendar. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1171 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1172 be referred to the Committee of the Whole with favorable recommendations. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1173 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, after consideration on the merits, the committee recommends the following: House Bill 1174 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1175 be referred to the Committee of the Whole with favorable recommendations and with a recommendation that it be placed on the consent calendar. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1176 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1177 be referred to the Committee of the Whole with favorable recommendations. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1178 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1179 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1180 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1181 be referred to the Committee of the Whole with favorable recommendations. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1182 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, the Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1183 be referred to the Committee of the Whole with favorable recommendation. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1184 be referred to the Committee of the Whole with favorable recommendation and with a recommendation that it be placed on the consent calendar. February 15, 2022, Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1185 be referred to the Committee of the Whole with favorable recommendation and with a recommendation that it be placed on the consent calendar. February 15, 2022, the Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bill 1186 be referred to the Committee of the Whole with favorable recommendations. February 15, 2022, Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1187 be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar February 15, 2022. Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1188 be referred to the Committee of the Whole with favorable recommendation, with a recommendation that it be placed on the consent calendar February 15, 2022. Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1189 be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar February 15, 2022. The Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1190 be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar February 15, 2022. Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1191 be referred to the Committee of the Whole with favorable recommendation February 15, 2022. Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1192 be referred to the Committee of the Whole with favorable recommendation, with a recommendation that be placed on the consent calendar February 15, 2022. Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1193 be referred to the Committee of the Whole with favorable recommendation, with a recommendation that it be placed on the consent calendar February 15, 2022. The Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1194 be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar February 15, 2022. Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1195 be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar February 15, 2022. The Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1196 be referred to the Committee of the Whole with favorable recommendation February 15, 2022. The Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bill 1197 be referred to the Committee of the Whole with favorable recommendation February 15, 2022. The Committee on Appropriations, after consideration on the merits, the committee recommends the following. Senate Bill 34 be referred to the Committee of the Whole with favorable recommendation, and with a recommendation that it be placed on the consent calendar February 15, 2022. The Committee on Appropriations, after consideration on the merits, the committee recommends the following. Senate Bill 78 be referred to the Committee of the Whole with favorable recommendation, with a recommendation that it be placed on the consent calendar.
Message from the House.
The House has passed on third reading and transmitted to the Reviser of Statutes House Bill 1074. The House has passed on third reading and transmitted to the Reviser of Statutes House Bill 1008, amended as printed in House Journal February 14, 2022.
Message from the Reviser.
February 15, 2022, we herewith transmit without comment House Bill 1074 without comment as amended House Bill 1008.
Announcements. Senator Janal.
Thank you, Madam President. Local government will meet at 2 p.m. today. We are going to be hearing 4 bills. Senate Bill 60, 59, 75, and 65, and that's in Senate Conference Room 352. See you then.
Senator Gonzalez.
Thank you, Madam President. Colleagues on the Senate State Veterans and Military Affairs Committee, we will be meeting at 2 p.m. in the old Supreme Court, and we have a number of bills under consideration. However, we are going to lay over Senate Bill 110 on the calendar, and we're going to change the order of the bills that we hear. We will hear the bills in the following order. I'll also repeat this at the beginning of committee. We'll hear Senate Bill 12, then Senate Bill 85, then Senate Bill 101, then Senate Bill 96, then Senate Bill 48, then Senate Bill 109, followed by Senate Bill 73. Thank you all.
Senator Winter.
Thank you, Madam President. Transportation and Energy will be meeting today at 2 p.m. in 357. We will be hearing appointments to the Aeronautical Board, the Clean Fleet Enterprise, and Senate Bill 108 with Senator Liston.
Majority Leader Senator Moreno.
Thank you, Madam President. Colleagues, the Senate Appropriations Committee had the supplemental bills in appropriations this morning. All the information you need is in this booklet right here. You all received it on your desk. Just a reminder that if you have amendments to the supplemental package, they are due by 4 p.m. today. And if you have questions about who you submit those amendment requests to, please contact your respective JBC member in your caucus, and we will help you through that and get you connected to the right folks at JBC staff. So a reminder, amendments for the supplemental package due by 4 p.m. today.
Majority Leader Fenberg. Majority Leader.
Thank you, Madam President. To our JBC member, thank you for that announcement, but there's something far more important due by 4 p.m. Let's be honest.
Please, Chamber, can the Majority Leader please have your attention? Majority Leader Fenberg.
Thank you, Madam President. By 4 p.m. today, get your merchandise order in. If you have any questions, concerns, you need advice, that would be today, 4 p.m. Please check in with Dave. If you have questions or problems, I ordered a nice fleece. If you want to match, it was black, has the pocket right here, so we can coordinate. But get those in. If you don't get them in by today at 4 p.m., you will pay a premium and probably also have to pay for your own shipping. But I'm sure nobody will miss the deadline, and we all will have fancy new outfits. Madam President, I think we have done plenty of business here today. We do not have anything more to read across the desk. So, Madam President, I move that the Senate adjourn until 9 a.m. tomorrow, Wednesday, February 16th.
You have heard the motion. Seeing no objection, the Senate will stand in adjournment until 0900 hours Wednesday, February 16th.